Hi, my name's Michael Craig. I'm a patent attorney and partner here at Browse McDowell. Today we're going to talk about intellectual property, which can cover things like patents, trademarks, copyrights, trade secrets, licensing, and a whole slew of other things. However, we're just going to talk about patenting today. So one of the things we think about when people have the question is, what are the patent rights? What does it cover? Well, patents are a way for the government to give you a monopoly on a particular invention, and it lasts for 20 years from filing. But in return, you have to disclose fully what it is you're actually inventing, so that after that 20-year period's over, other people can practice that exact same invention. So it stops people from practicing that. You have exclusive rights to practice it, or not. You can have the right to license it to other people, and you can enforce your rights by infringement actions. Some other questions we get is, what does it actually cover? Well, there's a rule in the patent laws that state that any new and useful process, machine, manufacture, or composition of matter, or new and useful improvement thereof can be patented. However, that kind of sounds like everything under the sun, and really it almost is everything under the sun, except for laws of nature can't be patented, and abstract ideas can't be patented. And there's a couple things that per se can't be patented, like software per se can't be patented, and perpetual motion machines can't be patented. So how do we get like apps covered and things like that? Of course, that seems to be a heavy area. Well, apps by themselves can be patented. It depends on the idea and how it's being used. The software itself may not be. So really, the rule of thumb is almost everything under the sun, except for those few exceptions that I noted. There's a few complexities in there. So what is the process? Well, we file an application with the US PTO, that's the Patent and Trademark Office, and then they decide whether it's worthy of a patent or not. So only people who are eligible to practice, only people that have gone through the licensing process to practice before the PTO can actually file applications, or the inventors themselves. So I'm a patent attorney. That means that I took the regular bar exam, and then I took one with the USPTO. We're attorneys on the outside, but we're scientists on the inside. So that kind of distinguishes us a little bit. Now, a patent is based on the claims, and claims is the wording that we use to describe the invention specifically. And then we file the application with the claims. The examiner takes a look and invariably says, well, that's not patentable because it's not new, or it's obvious. It's an obvious change of something that's already out there. So we have to convince the examiner and the PTO eventually that we think it's eligible based on the claims, and we work with them and we get to a process where we both agree that's a patent eligible invention. And then you have a patent that lasts for 20 years after that. If you have any questions, feel free to give us a call here at Browse.